Hey, welcome back to Final Affairs, where we talk about the legal side of life and everything that happens when we plan for the future or fail to. I'm here to keep you informed about the latest developments in estate planning, elder law, and business law. We're going to be breaking down the legalese into real life scenarios and practical advice. So today, specifically, we're diving into updates you need to know about from December 2024 as the year almost comes to a close. Let's get started. See, estate planning is about more than just a will. It's about protecting your assets. It's about avoiding unnecessary taxes, and it's about making sure your wishes are carried out. This month, the IRS issued private letter rulings that could have big implications for people with trusts or those working to avoid generation skipping transfer taxes, also known as GST taxes. So let's unpack what this means and how it could apply to your life in particular. All right, so imagine this. Sarah is a grandmother who wanted to leave a large portion of her estate to her grandchildren, skipping her own children to provide for the next generation. Sounds generous, right? But here's the catch. There's a specific tax called the GST tax that's designed to prevent people from skipping generations to avoid taxes. Now, Sarah's lawyer missed the deadline to file paperwork opting out of an automatic GST exception allocation. Normally, this mistake could cost her family thousands in taxes, but the IRS recently ruled that in cases like this, where the missed deadline was due to professional oversight, the taxpayer could be granted an extension. This is a very big deal because it shows the IRS is willing to be flexible in situations where honest mistakes happen. How often does that happen? So this story highlights something that is crucial. Deadlines, of course, matter, but there's room for remedy where mistakes are made. If you have a trust or are planning one, make sure your documents are up to date and your deadlines are tracked. Work with professionals who specialize in estate planning, and absolutely do not be afraid to double check their work. Yes, they're the professional, but also feel empowered to double check their work. Let's break that down further with another example. All right, so take Lisa and Kevin, for example. They set up a trust for their 3 kids and assumed everything was handled. But when they went to revisit their trust 5 years later, they realized their lawyer had failed to opt out of the GST allocation for a property they intended to transfer directly to their grandchildren. They were, of course, devastated, thinking they'd face a huge tax bill. But thanks to the recent IRS ruling, however, they were able to request an extension and correct the error. And this saved them thousands of dollars. The lesson here is that estate planning isn't a one and done deal. It's a living, breathing process that needs to be revisited and revisited regularly. Tax laws change, family dynamics evolve, and you need to stay on top of it all to avoid costly mistakes. Regularly meeting with your estate planning attorney is key to catching these issues before they become something that's going to be a very costly problem for you. Let's move on to another estate planning issue, and that's the trust modifications. So picture a family trust set up 20 years ago where laws were different. The terms of the trust, they no longer make sense. It was set up 20 years ago. And the family, they want to update it. They're worried though, because changes to a trust can sometimes trigger unintended tax consequences. This month, the IRS issued rulings confirming that certain trust modifications, like adding a new trustee or clarifying distribution rules, won't automatically trigger GST taxes. This gives families more freedom to adapt their trust to modern needs without fear of a tax bomb. For instance, imagine another imaginary family, the Johnson family in this case. They had a trust that was created in the 1990s, and that trust dictated strict distribution schedules for their children. Now, those children are in their 40s, and the family wants more flexibility to provide funds for grandchildren's education. Under the recent rulings, they were able to modify the trust to reflect their current priorities without triggering additional taxes. All right, let's break it down even further. Consider another scenario. A trust specifies that assets can only be distributed to beneficiaries after they reach the age of 30. One beneficiary faces unforeseen medical expenses at age 28, and the family wants to update the trust to allow for an early distribution to that family member. With the latest IRS guidance, such a modification can be made without tax penalties, provided, however, that it's done carefully and within the guidelines. So if you're considering modifying a trust, absolutely consult an estate planning attorney like myself. Even if it seems like a straightforward adjustment, getting legal advice ensures you're not stepping into a tax trap. This brings us to the big takeaway here. See, estate planning isn't just what you have. It's about how you protect it and pass it on. See, in each of these scenarios I've given to you, no one has passed away. These are just trust instruments and its modifications to a trust instrument. Remember, the cost of regular updates is far less than the cost of litigation or unexpected taxes. All right, so let's shift gears a little to elder and special needs law. The government has released new figures for Medicaid eligibility and veterans pensions for 2025. These changes might seem technical, but they can have a big impact on how families plan for long-term care or assist loved ones with disabilities. So let me break that down. All right, in this instance, we're gonna meet James. James is a retired teacher who needs long-term care. His family is worried about the cost. Nursing homes can cost upwards of $100,000 a year. James has some savings, but obviously not enough to cover years of care. This is where Medicaid can help, but eligibility depends on very strict income and assets limits. For 2025, these limits have increased slightly, meaning more people like James might actually qualify for Medicaid. But here's the tricky part. Medicaid has a look-back period. See, if James transferred assets to family members within 5 years of applying, he could be disqualified or he could face penalties, as though he was trying to do a fraudulent transfer to be eligible for Medicaid, essentially. But let's add another layer to this scenario. Suppose James transferred his second home to his daughter 3 years ago, thinking it would simplify things. That transfer could jeopardize his Medicaid eligibility unless he works with an attorney to address the penalty period. This is why planning early is so important. If you or a loved one might need Medicaid, start planning right now. Work with an attorney who specializes in elder law to protect assets while also ensuring eligibility for Medicaid. Now I want us to consider the case of Evelyn, a widow who wants to protect her home while also qualifying for Medicaid. She sets up a Medicaid Asset Protection Trust. By transferring her home into this trust early enough, she avoids issues with the look-back period and ensures her home is preserved for her children. So what that means is the trust owns the home, she does not, and so it does not count towards her assets. Now let's talk about our veteran. Maria is a widow whose husband served in the military. She struggles to make ends meet, but she qualifies for a VA pension. The new rates for 2025 mean Maria could receive a bit more each month, a small but meaningful increase for her budget. What's important here is that many veterans and their families don't realize they're eligible for these benefits. The VA pension isn't just for combat veterans. It's available to anyone who served during wartime and meets certain financial criteria. So if you or a family member served in the military, check your eligibility for VA benefits. You might actually not know that you are leaving money on the table. These updates to Medicaid and VA pensions are a reminder that public benefits can play a critical role in financial planning, but the systems are complex and getting the most out of them often requires professional guidance, of course. It's never too early for you to start asking questions and seeking advice from knowledgeable professionals. But finally, I do want to shift gears and let's talk about business law. If you own a business, or if you are thinking about starting one, like myself, I own a law practice and I'm actually a co-founder of a startup. I want y'all to listen up as I listen up as well. This month, a federal court issued a nationwide injunction delaying the new Corporate Transparency Act deadlines. What does this mean for you? Let's go ahead and unpack it. Imagine you own a small LLC with a few partners. Under the CTA, you're supposed to report detailed information about the company's beneficial owners, essentially anyone who owns or controls a part of the business. The deadlines for these reports were coming up very fast, but the injunction has hit the pause button, and I know a lot of you were nervous about the CTA. So why does this pause matter? For small businesses, compliance can be a headache. The CTA is designed to prevent money laundering and fraud, and I've talked about this previously on some of my channels. But for regular businesses, it can feel like just another layer of red tape. So I guess you can use this time that you have been given with the pause, this extra time, use it wisely. Learn what the reporting requirements are and make sure your records are in order. If you're not sure where to start, consult a business attorney or accountant. I'm a business attorney and I can certainly refer you to an accountant. But now let's say you're a consultant who advises startups. Let's give an example. You've been helping a client get their LLC in compliance with CTA rules. The delay in deadlines gives them some breathing room, but it also means the government might tighten enforcement later. So these are the things that you have to stay ahead of. You have to stay ahead of the curve. Just because the deadline is delayed doesn't mean you should wait to act. Being proactive now can really save you from scrambling later. The CTA is part of a larger trend towards transparency in business. We got to think about the bigger picture here. So whether you're a solo entrepreneur or if you're running a growing company, it's important to understand how these laws affect you and to get professional advice when needed. And remember, fines for non-compliance can be substantial. Again, I've covered this on my channel. So I don't want you to wait until the last minute to try to get yourself in compliance. The pause is really just additional time for you to get your ducks in a row. So what's the big picture here? Whether we're talking about estate planning, elder law, or business compliance, the key is preparation. These updates show us that laws and regulations are constantly evolving. Staying informed and working with the right professionals can make all the difference here. Thank you for joining me today on this episode of Final Affairs. Until next time, y'all, stay rooted in the law and in life, and happy holidays.